the issue of fiduciary. And this is really important. So what is a fiduciary? So people who don't know what that means. A fiduciary in a public union welfare fund is an individual or entity such as a trustee, a fund administrator, or an investment manager who has the discretionary authority or control over the management, assets, and administration of the fund. They are legally and ethically obligated to act solely in the interest of the participants and beneficiaries, public employees, to provide benefits and pay reasonable expenses. While public sector plans are generally exempt from federal ERISA, that's their Employee Retirement Income Security Act, ERISA, the trustees of these funds are still bound by the high standards of loyalty and care, often similar to the ERISA principles. The core fiduciary responsibility. Fiduciaries in public welfare funds must adhere to the following duties. The duty of loyalty. Duty of loyalty is an act for exclusive purpose of providing benefits to participants and their beneficiaries. They must put the interests of the members above their own, the union's or the employer's interest. Do I need to repeat that a second time? The duty of prudence, which is care. Act with care, skill, and diligence that a prudent person familiar with such matters would use. This includes making informed, rational decisions regarding investments of funds and the management of those benefits. Compliance and plan documents. Follow the governing plan documents where applicable, state or local laws, which we know here there really aren't any. Avoid conflicts of interest. Refrain from engaging in transactions that benefit parties related to the plan, such as service providers or the union itself. Diversification. Diversify investments to minimize the risk of large losses unless it is clearly prudent not to be able to do so. Who is the beneficiary? Beneficiary status is based on the function performed, not just a title. Key individuals usually include fund trustees, which are individuals responsible for overseeing the trust fund. Plan administrators. These are exercising discretion over claims and eligibility, and the investment managers. That's common sense. Consequences of breach. Fiduciaries who fail to meet these standards may be personally liable to restore any losses to the fund or restore any profits made through improper use of those assets. Now, that is a lot to consider. I know I saw Ellen goes, oh my God. But you guys, that was one of your first concerns, was it may not have been so much legal, but it would have been in a fiduciary capacity, which is what I wrote about the other day.
Absolutely. And this body of law is actually very ancient and is well established, including in New York State because of the age of New York State and being the one of the early centers of union activity and creation of welfare funds. So there's not much question about what fiduciary duty is.